Howdy, we're back, and I'm happy to say that the issue with you not getting access to the book in PDF form in the library has been cleared up. This was not a problem with the course, nor a problem with Texas A&M. Apparently it's a problem with the Wiley system. But anyway, it's back, and so I want to get us back into it. You've had some time off. Hopefully you're writing those papers. I believe we have everybody's topics set. You know, as always, if you have any questions, if you need help with resources, if you want to just talk about some issues, send me an email. We'll set up some time. I'm going to talk about Chapter 10, but I'm only going to talk about pages 340 to 345. And here's why. This is an extremely, extremely important topic. I want you on your own initiative to do some Googling and look up GDPR. I'm going to hit the highlights here. It's a complicated law. For instance, I had my class at U of H, spring of 2017, for the semester, dissect the law, come up with it, try to understand it, and it was just overwhelming. We found conflicts in the law. The courts haven't ruled on it yet. But it's here, and it's now. It was passed May 25th, 2018. It was originally passed with a 2-year horizon to say it's going to be fully implemented. There's already been some rather large fines, investigations. Pottery Barn, for instance, no longer has a website accessible to the EU countries. It's not going to get around the problem because, as we'll see in a few minutes, we'll discuss it, other countries are now picking up on GDPR. So a little bit of history is, why are the Europeans have such a different notion of privacy than the U.S.? And I know we haven't talked about U.S. privacy laws. That's next. However, why are they so, I don't want to say hung up, but why is their emphasis on privacy so much different than the U.S.? In the U.S., we have the Bill of Rights. We believe that there's things we do for privacy. We're concerned with it, but we don't have these kind of laws enacted. Well, it goes back to their history, and that is both in Nazi Germany and when the Soviet Union took over Eastern European countries. And public records were very meticulously kept, and these records used to target specific groups by Germany. And also in the Soviet Union, when the Soviet Union fell and the records became open, how much incursion against privacy had occurred, people spying on their own family members. And so they have a different notion of privacy than we do. And I wanted to lay the foundation for GDPR because I know some of you are doing papers on it, and it is something you need to be following. No matter what your job's going to be, if it affects if it's at all touching the keyboard, if it's data, you need to keep up on what's going on with this legislation because privacy is our tipping point. We have had so many cybersecurity attacks, but there's something about when people's privacy is given up that the situation is going to change. We're going to see more legislation like this. So a bit of the history is, for years, the European Union had this safety privacy shield that said, safety harbor that said, hey, if you're a European country and you're doing business in the U.S., you come under U.S. law, okay? Then that was retracted by the privacy shield, where companies could self-assess themselves and say, we're doing everything you want us to do. Well, as I said, the historical background of the emphasis on privacy by Europeans, but also Edward Snowden's revelations about what was being, the NSA was eavesdropping and spying and all this. So here is a critical point, and we're going to talk about this over a couple of lectures, but I want you to put this in your head now. Europeans view privacy as a fundamental human right. So if this were an in-class conversation, I always start with this and say, how many of you think it's a fundamental human right to be safe? Every hand goes up. How many of you think it is a fundamental human right for civilians not to be massacred by military? And every hand goes up. How many of you view as a fundamental right the access to education? And every hand goes up. And then something interesting happens. Along the way, I ask the question, how many of you view as a fundamental human right the right to free education? And typically, very few hands go up, and those are international students. That is the difference in privacy. Saying it's a fundamental human right is a statement, but we don't know what encompasses human rights. So obviously, to be safe, not to be killed by the military, to have access to basic life essentials, food, shelter from weather events, there's certain things that we say every human being in this world deserves this. But then there's this, wait a minute, no, we're Americans, we tend to think you pay for your education. No, we're from another country and we believe this is a fundamental human right. And I'm only using that as an example. Saying privacy is a fundamental human right gets into the same notion. What is privacy? What is privacy? And we're going to come back to this question in the next couple of lectures. So you can check out this. Is privacy a human right or civil liberty? And a human right is a right justifiably believed to belong to every human being, as I've said. The right to be safe, the right to, certain human dignities. But a civil liberty is the freedom of a citizen to do something, to be free from discrimination is civil rights. Civil liberty is the freedom of a citizen to exercise customary rights of speech or assembly without unwarranted or arbitrary interference by the government. So in the U.S., we have our Bill of Rights, and we all talk about our First Amendment. We have our First Amendment rights to free speech. Well, typically people get it wrong because of a company. The Bill of Rights only applies to government, federal, state, local government. It doesn't matter. Under the 14th Amendment, it's all the same. But it prohibits the government from inhibiting our speech. It prevents the government from allowing us to demonstrate. It prevents the government from preventing us to do our religion and the like. So that's a civil liberty, and in the U.S. we have that. And then we have civil rights, which is a basic right of freedom from discrimination. And again, this is not a yes or no question. You've seen in the last 10 years or so civil rights being encompassing more groups, LGBTQ groups. We have this right not to have discriminate against transgender. We have this right, and we have this right. So my point is this, not to say this is the right way approach, this is the wrong way approach, or this is what I believe in, or this is what I believe in. It doesn't matter. It's to understand how we use these terms: human right, civil liberty, basic freedoms, and then civil rights. And in some ways, all of them are moving targets. So what does GDPR give us? Well, first of all, it gives us extraterritorial jurisdiction, meaning it applies to the processing of data wherever it occurs. Now, there's two different camps. The courts will have to figure this out. Excuse me. I read the law that it says if you process data on a citizen or resident of the EU, you come under this. Other commentators, and there's a group of commentators that agree with me. Another group of commentators says, no, it only applies to the processing of data if it occurs within the EU boundaries. Well, I always like to say, if this were in class, let's name the EU countries, because I think there's 28 of them now. And it turns out there's this whole, the EU countries aren't necessarily what we think they are. There are 3 countries in Europe that have never been in the European Union, never will be. Aside from Britain, who's trying to exit. There's Norway, Liechtenstein, and Switzerland. Never been in the EU, never going to be in the EU. People are amazed with Norway. Well, what about Finland, Denmark, Sweden? No, they're all in the EU. Then you have the former Baltic republics, Estonia, Latvia, Lithuania. You have Turkey, who has tried unsuccessfully for decades to be in the EU, which, quite frankly, in my opinion, would have been a good thing. You have countries that are definitely in the EU. Then you have what's called EU-A countries, the 3 I mentioned, who by treaty, agreements and the like, have interface to the EU, which is why when people talk about Brexit, just follow the Norway template. When I was in Norway, I used to travel to Norway quite a bit. And I was asking Norwegians, why weren't you in the EU? And I'd kind of get a philosophical answer. And then finally one day someone told me, we're not going to have Brussels tell us how much oil we can take out of the North Sea or how much fish we can do in the North Sea. Because the EU, in fact, controls the economies of these countries. So in my opinion, it's a very strange concept to Americans that someone can say, no, you can't grow this. Yes, you can grow this. Because they try to balance the economic overall picture. So first of all, when they talk about extraterritorial jurisdiction, it gets complicated right there. Second of all, a key change are the penalties, and this is why Pottery Barn withdrew their website from EU. The penalties are the larger of 20 million euros or 4% of gross international sales for violating the EU, for violating GDPR. Now, they have already had, as of May 25th, there was a rush to start bringing in investigations. There haven't been fines levied yet. It's only been in effect a couple months. However, that's a mighty big fine, a minimum of 20 million. So theoretically, a mom and pop shop, selling handicrafts on Etsy or something, could get hit with a 20 million euro, which in today's money is probably, I don't know, euros down, maybe $25 million. Third big change is consent. That the data subject, which is defined, data subject, has to give consent, explicit consent. You cannot opt, there's no automatically opting in. You have to give explicit consent at every step, which means if there's a cookie on your machine, you have to be explicitly asked, throughout the life cycle stages. In the US, again, we tend to do blanket, yeah, I agree to these terms and conditions and go on. Nope, wouldn't fly under GDPR. Then there's the data subject rights. The data subject rights are individuals. Data subject, I always love this. Why don't they just say individuals? But whatever. You have a 72-hour requirement for breach notification. So if I have evidence of reasonably believe, and I think the courts are going to say, or should have known, that there was a data breach, I have 72 hours to notify you. That's draconian by U.S. standards, and I am not saying U.S. standards are right as a victim of many data breaches, but it took Equifax, I think, 3 or 4 months to notify people. The only thing they got done within 72 hours was when their C-suite dumped stock. Again, this could incur a large penalty. You have the right to access your data. Well, that makes sense, but you have the right to know what data is out there. What data is Google tracking me for ads? I want to know everything you have on me, okay? How much of my history have you stored? What do you know about me? Sounds great. I agree with that one. No one should be keeping data on us that we do not know about. Then you have a big one, the right to be forgotten. The right to be forgotten is this. I don't want you handling my data anymore. I want you to get rid of all of it. I want you to get rid of all of it that you have on your system, on your backups, whatever. A couple problems with this. One, as a lawyer, for instance, I have to keep records for a certain number of years required by the state bar. So if you come to me and say, I don't want you to be my attorney anymore, and you've got this data on me, I want it to be forgotten, I want you to delete all of it, I can't ethically. I can say, when that time period is up, I will delete all the data and let you know, but there's a conflict. No, you're saying delete it now. The second of all is balance personal privacy with the right to free speech. A lot of people are saying, wait a minute, the right to be forgotten. I was taking pictures, I was doing this, I was taking this thing. Okay, yeah, I got this person in it, but I have a right to free speech, I have a right to express my opinions. This didn't really cause this person any harm or damage. Right to be forgotten came from a big case that a woman had against Google in Europe, where her ex-boyfriend posted revenge porn, pictures of her on the internet, and she successfully sued Google, and the European court said, Google, you have to get rid of all copies of this. Well, Google can say, look, we can maybe do something in our search engine, but we can't get rid of all copies because this is the internet. We don't know where all the copies are. They could be cached someplace. Somebody could have downloaded them. How do we do this? Then you have to have data portability, which is just what it says, the ability to move your data. Another big one is you need privacy by design. If you're a software developer, ding, 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 this should go off in your head. Now the GDPR says you have to not put privacy in as an afterthought, but in the design of your systems. Again, there's a question. What if it's an existing system? How can I do privacy by design when it's an operational system? And the last one is data protection officers, and companies over a certain limit have to appoint a data protection officer, and that person has to have certain qualifications and is the focal point of any type of breach. Well, that's great if you're a software company, But let's say you're a company that makes floor tile, right? And yeah, you've got an IT staff, but you're going to have personal data because you're going to be accepting credit card transactions. Like who in this company can we certify and who legitimately say qualifies as a data protection officer? We're a little mom and pop shop. We might outsource our IT. And I did say there has to be at least 250 employees, but think about it. In a manufacturing facility, it's very easy to have over 250 people. None of them doing IT work. They're making the floor tile. So here's a key issue on GDPR. What is personal data? And this every time I get on this topic, I'm still just overwhelmed. And I have kept on top of this for the last couple of years. Anything that I can find to read, any seminar I can go to, any conversation I can engage with lawyers who are doing this as part of their practice. And this never ceases to catch my attention, that the definition of personal data is any information that is relating to an identified or identifiable natural person. And it's one who can be identified. Now, follow along when I'm reading this to you, directly or indirectly. Who can be identified directly or indirectly, in particular by reference to a name, okay, identification number, okay, location data, yeah, location data, wait it, ding, ding, ding. Remember the Carpenter opinion a few weeks ago. An online identifier, ding, 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 is that my IP address? And this is the big one, or to one or more specific factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. Currently in biometrics, I have read, and I probably need to update my knowledge on this, that we are getting to a point that we can come up with about 50 characteristics that will uniquely identify you and the planet. Okay? The way you walk, the length of your fingers, the angle between your index finger and your thumb, your nose, whatever. Your signature of behavioral characteristics, as I said, how you walk, how you write. So when we say personal data, this is a key question. Can you identify that person by the data? And what does that data encompass? Second issue. Big disagreement on the scope of jurisdiction. Sorry, I don't have an answer for you on this one. There have been no court decisions yet. And then you have the EU, as I said, the EUA, okay. Canada and Mexico are looking to implement GDPR, and that's why I'm not following those pages in your book. I'm just looking at GDPR. Please read them if you're interested, but unless you're going to be interacting with them, and if you are going to be interacting with them, let's say you get a job in a year or two, then I say you go right immediately and check the latest law. South American countries have begun implementing GDPR. Singapore has implemented GDPR. The New York law on financial institutions and vendors took a lot of the key concepts, including the 72-hour breach notification. And just within the last few weeks, California passed a sweeping law to protect online privacy that it's being called their version of GDPR. So it is surrounding us. It is taking us over. And I wish I could say, here's some black letter law on this, on this, on this, and this. Black letter law means there's no discussion. This is the way it is. However, I can't. So take it to heart when I say you need to follow GDPR, no matter what your job is. We live in a global economy. We live in an international community. I live in Houston. I used to work in oil and gas. I don't know. I'm sitting across the table from someone and they let me know, unless they have an accent and something keys me off and I say, oh, which country you're from. I don't know where they're from. Last semester when I taught this course, I didn't realize I had a resident of an EU citizen sitting in my class until probably halfway through the class. And then it was a country that I didn't even recognize as being in the EU because it's a former European or Soviet bloc country. So my point is, no black letter law. Lots of questions, lots of things to watch. When this law was being set up and everybody was looking at May 25th, 2018 as being, the day the world changes, I predicted, as many commentators, that, hey, they're going to pick a large American technology company and go after it. Google, Amazon, Facebook, whatever. Our big technology companies are all American, correct? Well, Cambridge Analytica came on and Facebook basically handed it to them on a silver platter with a big blue ribbon on it. So you will see investigations into the two biggest ones probably are going to be Google and Facebook. So I'm going to just go through this. If you have two types of companies, your controllers, which you determine the purpose and means of processing personal data, and you're responsible for ensuring that these processes provide sufficient guarantees. So for instance, I can't say, hey, look, I'm the tile company and I outsource this to an IT company. It's on them. Yes, it's my finances, yes, but I'm paying somebody. No. You can delegate authority, you cannot delegate responsibility. You are the controller. You're telling them what the purpose and means of processing that personal data is. When I say you are processing the data to get me paid for my porcelain tile or something, floor tile. Then you have the processors, which just are those that have personal data on behalf of the controller. Now, there are certain obligations on each. However, a big part of GDPR, again, is you cannot use as a defense, I don't have hands on my data. I'm paying someone to do my data. I'm doing it, I'm a third party. That's going to end our talk on GDPR. Please read those books, pages in the COSF book, and I will be back to you shortly. And also, please stay up on with your paper and come to me if you have any questions. Thank you.